So the first news we want to go over is ICE detaining people at the airport. And there's a New York Times article about that. We're seeing ICE officers have been stopping different people. And how this is happening is because when you board a flight, with the name and information you provide, the TSA writes everything out. And once they write everything out, ICE gets a copy of that. And once ICE gets a copy of that, they double check it with your I-94 record. It's almost instantaneous. AI is able to spit it out right back to them. And at that point, ICE is making a determination. Do they want to go to the airport and stop you? And we're talking about domestic airlines, right? So you're flying from California to Hawaii, from Hawaii to Alaska. It's a domestic airline. But still, there's ICE agents at every single airport, and they could see. And it's up to them to make a decision. Do they want to go and detain you before your flight or after your arrival, right? Because they see everything. A lot of people are saying that this is incredibly not right. A lot of people are saying even though it's an I-94 expiration, they've already filed an adjustment of status. Why are you still detaining them? And in the past, domestic flights, ICE doesn't spend time doing that. It's usually only on international flights if there is a problem or if they're crossing the border and there's a problem. Domestic flights has never been an issue. Last year we saw this also with DACA recipients. People who have had valid work authorizations, people who have been here for forever, and now they even have a DACA approval, and yet being stopped at a domestic terminal. Now, what ICE have repeatedly said in the past year now is that just because you have authorized stay does not mean you are not removable. In other words, I can still pull you into proceedings. I could still put you in removal proceedings even if you have DACA, even if you have a pending adjustment of status application. And the reason is because your I-94 expired. The moment your I-94 expired, the moment you don't have official status in the US, then you are in limbo. You have authorized stay to file a case with USCIS to potentially get a green card, but who's to say USCIS will guarantee approval? So I could put you in removal proceedings. That's ICE's line of reasoning. A lot of lawyers, a lot of clients, a lot of people push back against this rationale saying, no, you've never done that in the past. People have authorized stay. You shouldn't do that. ICE pushes back saying, well, we chose not to do it in the past. We've always had the legal authority to do it, but because of funding, because of various reasons, we didn't prioritize this area of enforcement. If you're here, you have no criminal record, we weren't focusing on domestic airline travel. But now we can. And so that is what we're seeing. That's the line of argument that they're pushing. DACA removal, what you have authorized stay, sure, but that's only deferred removal. We can remove you at any time should we choose. You could still win it at court, but that's up to the judge. My job is just for enforcement. So basically, starting from last year till now, the enforcement arm of immigration, ICE, they have a quota. And now we're seeing this news happen. Is it happening at every single airport? I don't think so. From the way I'm reading the article, from our own clients traveling, from a lot of things we're seeing, I don't think they're enforcing it en masse, because if we're truly calculating how many people who have I-94 overstays, who are pending 45 adjudications, who are DACA, who are traveling internationally, that's going to be in the probably tens of thousands every single day. We're not seeing tens of thousands of people being arrested every single day, but a few cases being detained and then being released is enough to cause this New York Times article. ICE's authority have expanded. ICE's funding have expanded. Their quota have been set. And is this a threat for people who are in a pending state of 45 adjudication process? Yes, that is, I think, the scary thing for a lot of people. And it's confusing. Again, they've always had the authority. They chose not to exercise it in the past. They didn't have the funding in the past, but now they do. And if you are the unlucky individuals that are getting picked up, that are putting in proceedings, that's sort of the state of reality. That doesn't mean everybody's going to be locked up in detention for months and months. It could just mean they detaining you, bring in, giving you an NTA, and now you have a notice of intent to appear in immigration court and a USCIS case going simultaneously, and now you have to go to immigration court to try to close out this case and transfer it back to USCIS or vice versa. And we've done that, right? Yes. Gabby and I, we've done these type of cases, but now you're just in an extra, you have an extra step to do, right?
Yeah, Gabby, I'm curious, what was your reaction when you first heard this news?
I honestly was not surprised, and I think it's just, with the current administration, anything can happen. Any day that you wake up, you have news about, something going on or a new memo or a new policy. But what was interesting is that now, even if you have a pending case, they are still detaining people, which, it just complicates the process, but it also adds a lot of pressure, I think, both on the government and the public, right? Like the government now needs to process more people in proceedings. There are a lot of more resources that are wasted. And what if you go to court and the judge looks at it and says, why are you even here? Like, you're already fixing your status. Mm-hmm. I'm going to just close your case, just go back and continue your adjustment of status, right? So then you just wasted time, money, and, gave someone a headache that was not necessary. So I think I was not surprised, but it's just that seeing things from my perspective, it's like, I think it's unnecessary, but the law is the law. Yeah, just being very diligent on, not traveling, I guess, now, if you have a pending case, or consulting with your attorney before you make any traveling plans. I think it's the way to go right now.
The people who are being picked up is their I-94 have expired. So maybe you come in as a tourist visa, you're granted 6 months of I-94 authorization. If you want to continue to stay, you need to file an extension. Or you need to change the status to become a student, and you have an extra couple years. But that I-994 controls how long you are lawfully present. And within that time, you can change status to another status, you can file adjustment of status, you can do a lot of things. That's why we have a lot of clients who on F1, they change to H1B status, and then while they're on the H1B status, they file for adjustment status to get a green card through work or through family. But usually we still tell all our clients, still continue your H1B. Don't just give it up immediately. Technically you can, but just to be safe, keep it. If you're still a student in an F1 status, continuing being a student, continue to pay that tuition until you get your green card, and then right? We've always said that, and that I-94 controls your lawful status. But you could stop, and now your I-94 expires, your adjustment of status is pending, you're authorized stay because potentially you could get a green card. But if an ICE officer shows up and says, oh, your I-94 have already expired, your 45 is pending, well, just in case, I'm still going to pick you up, put you in immigration court, and now we'll let the judge decide if they want your case, if they want to adjudicate your case, or they want to close the case and give it back to USCIS. But I did my job because I saw somebody who might be deportable in the future, so I'm just going to pick them up now. So that's kind of their kind of rationale, right? If they're trying to meet that quota or anything like that.